The next set of, I think, questions is specific to FCRA compliance, right? And here I'm going to take a bit of a step back and briefly talk about something which I actually want to finish this conversation with. And that is the larger government position on NPOs, right? And this is a position which I have seen evolve over the last, say, 15 odd years, where there's an increased amount of regulation. There's much lesser forgiveness in the system towards an NPO. And there is an effective sort of bias against NPOs, at least when you start dealing with specific facts and specific situations with government. Now, it is correct to say that government has some reason to be skeptical because a number of people have used the NPO structure, if you will, to do things which just should not have been done, right? However, I think the way government is reacting, and consistently, right? It's not the present government of India. I'm just saying the larger regulatory mindset over a 10 to 15-year time span, I think has really been to throw the baby out with the bathwater, right? So rather than address those individuals or those entities which were problematic and were acting in breach of, let's say, ethics, morals, or even the law, what they've done is they've basically tightened everything to the point of absolutely no flexibility, absolutely no leeway, and they've imposed on not-for-profits a rigor of regulation which I think up-to-date not-for-profits in India have not fully realized, right? And this is something which I've spoken to Vijay about at great length in other contexts, so she can add if she needs to. But this is something you need to bear in mind, and you need to specifically bear this in mind with your FCRA compliance, right? The reason I say you need to specifically bear it in mind with FCRA is because FCRA, the statute itself, right, and the present statute as well as the earlier statute, which went back to the 1970s, functions on the basis that anyone who's receiving a foreign contribution is de facto doing something wrong. So before you can even receive that contribution, you come and you get our approval, right? And while we have seen a great degree of liberalization on foreign exchange regulations generally, right? I mean, today, if someone needs to draw Forex for something, it is a much simpler proposition than it was 10 or 15 years ago, and certainly much simpler than it was 20 years ago. However, FCRA has not changed in the substance of its regulation. And I would think that the rigor or the draconian manner in which FCRA regulations are being monitored and implemented mandates that every one of us who is either working in an NPO or who, like me, is advising NPOs needs to ensure that you are absolutely dotting the I's and crossing the T's, not only generally on your compliance, but with express focus on FCRA. So up to date, I have not seen any liberalizations on timelines for filing for FCRA approval. Or anything to do with your annual filings for FCRA or otherwise. I do not anticipate that you should hold out hope that something like that will be forthcoming. So, something which we've advised people as Bharucha and Partners is, if you've received the email notification or otherwise from FCRA saying, please let us know what your COVID-19 steps and actions are, of course, immediately reply and do everything that you need to. And if you haven't received that, log into your FCRA portal and try and provide that information. And we've done that. I think Toolbox also did that. You get a response saying this does not apply to you. That is what you really need to do to make sure that you're staying on the right side of the Ministry of Home Affairs. And I don't need to narrate to this audience the large number of NPOs which have been struck off the list or otherwise suffered penal action under the FCRA and its related stipulations. Like I say, there may be a large number of them who are actually deserving and meriting that kind of action. But there are also, I believe, and I know for a fact, a few smaller players who, frankly, as a matter of inadvertence or perhaps ignorance of the law or perhaps an expectation of flexibility, did not do exactly, and I cannot reiterate this enough, exactly what they were supposed to do. And that got them into trouble, right? So as far as FCRA is concerned, please don't don't do anything which is less than the absolute maximum that has to be done. And if you, yeah, sorry.
Sorry, Justin, there is one question which has come up, which is very relevant to the point you're making. One of the questions which has come up is, since non-profits are required, those who have received the notification under the FCRA that they have to upload their COVID-19 efforts, one of the questions raised was, can we undertake COVID-19 efforts which are not under as defined by the company's objects?
No, I'm going to pick that up towards the end.
Okay.
So I would put it this way. FCRA is not concerned with your company's objects per se or your society or trust's objects per se. It is concerned with them to the extent of course, all the papers you have filed at the time of seeking registration, and the money which you receive under FCRA has to be used only for FCRA purposes. That is the sort of the touch point for FCRA regulation. But if you start doing things which are not within your objects, I would certainly advise a great degree of caution for two reasons. One is generally the regulatory regime governing NPOs gives you flexibilities and relaxations under the Income Tax Act, under all sorts of other things, on the basis that you are fulfilling your objects, right? And a lot of those registrations are contingent, so they continue to remain valid for so long as you fulfill your objects. The moment you deviate, you start putting that entire structure into jeopardy. Now, a response to that construct may be that, Arey boss, how will someone really find out? Because I'm doing it, I'm not using FCRA money, and I'm really doing good work. It's not that I'm doing something which is, which is underhanded or is bad or something. I'm just working out there in the world. And the answer to that is your auditor. When your auditor has to audit your accounts, and the rigor which is being imposed on auditors is extremely high. In fact, auditors today are liable to imprisonment for a number of reasons. So they are going to call out deviations from your objects, right? So if you're doing something which is not related to your objects, whether it be COVID-19 or something else, I would say don't do it until you've amended your objects to reflect what you're talking about. And let me add a clarification here. Typically, objects are crafted as, when you write a memorandum of association or you write the objects of a trust or of a society, you typically have the main object or the principal object, and then you have ancillary objects which follow. So by and large, you should be acting within the realm of what is there in your charter, what is there in your document which sets the basis for your existence. The moment you move away from that document, right, I think you're asking for trouble, and you really should not be doing that. Okay, whether for COVID or otherwise. But if you can, and there is no answer in detail to this. Any detailed answer will depend on the specific constitutional documents you have, and you'll need to seek specific advice on that. But as a general construct, don't deviate from your objects unless you have to. And if you do have to do that, then you first seek amendment of objects and move ahead. And when you amend your objects, bear in mind that you as NPOs are registered across the board with a number of regulators. There may be sort of interdicts with each of those regulations. So it's not the easiest things to do. So I'll tell you for a fact that I know some NPOs who have lost their tax registrations under 12A80G because they changed their objects, didn't properly notify the income tax authorities. That got picked up in audit, got picked up when the returns were filed. Not only did they lose registration, they faced adverse tax claims, and then the directors and managers of those organizations, I know of two of them, got into some amount of trouble. So you want to be very careful with that.
So, Justin, just as a quick follow-up question to this, while I understand that there shouldn't be a deviation to any activity undertaken, what about relief efforts? Because I think it's a catch-22 for nonprofits, right? If they are required to report out what COVID activities have they been undertaking, does relief count? Let's say that the money that was used was either they've raised separate money for COVID-19 relief. I know that because Toolbox is sharing the appeal campaigns of at least 24 of our NPO partners. Are they allowed to report out relief, the relief efforts? I have another additional to this. On the other hand, you also find nonprofits who are in the space of education and so on, who've come out with do-it-yourself education toolkits at home. There are play toolkits at home, which is within the realm of their program, but they've also now started finding small activities and using virtual mediums now to stay connected. They are sending out guide cards on safe distancing, on how to manage your wash practices in your community, and so on. Could they report those out?
So I think it's easier to answer in context of the facts to your second question, Vijaya. What when you say that the entity in question is working in the field of education, the objects address that, then everything that you spoke about, right, a play kit or a toolkit or a do-it-yourself kit, which relates to the work that NPO is doing in its field and happens to also be addressing COVID, I think A is absolutely within the objects of such an NPO, right? And B is certainly something which should be reported or can be reported or otherwise, right? But let's take a different example. So let me assume for a moment that I'm an NPO which is supposed to be dealing only with people of a particular religious faith, right? And I have received my monies in trust for that. All of it is for that particular faith. And then I start doing, and I'm using the term, let me not use that word, but let's say I start doing multi-religious COVID-19 relief. There, I believe, yes, you will certainly report it. And it would certainly be valid for reporting into the FCRA or something else. But is that within the objects of your trust? Probably not. Right? I would think where you have to exercise a great degree of caution. So again, when FCRA has sent out these requests, right, saying please report your, when Ministry of Home Affairs sent out the request saying please report your COVID-19 activities and support, there's no statistic on this, and I haven't at least seen any statistic on this, but just going by experience and the questions that come our way, most of the people who receive those requests or receive those instructions to make that reporting are people who are actually, by virtue of the objects they have filed with FCRA, identified as people who can do stuff towards COVID-19, right? So I think that is the underlying meta. You cannot, any entity, and it's not specific to not-for-profit organizations, it's just across the board, right? Any for-profit company or for-profit partnership firm or anything cannot act contrary to its constitutional documents. That is the first rule of functioning as an entity.